Article 253 establishes the composition of each of the independent commission, and Article 253 provides its incorporation. Now, there has been interpretation both by this court and by the Court of Appeal as to what Article 138 it means. And in that respect, I would like to refer you to the case of Raila versus Electoral Commission, and that is the second petition of 2007, and at page it is starts at page 153. At page 153, this honorable court referred to the case of Maina Kiai, and in it stated as follows. Clearly, at paragraph 263, clearly this provision in mind, the Court of Appeal in Maina Kiai decision was categorical as it rendered itself. Thus, we are satisfied that this elaborate system, the electronic transmission of the already tabulated results from the polling station contained in the prescribed form, is a critical way of safeguarding the accuracy of the outcome of elections. I do not see how the appellant or any of its officers can vary or even purport to verify those results. Further, the Court of Appeal stated thus, and this is the important one: the appellant, as opposed to his chairperson, upon receipt of prescribed forms containing tabulated results for election of the president electronically, transmitted to it from the near 40,000 polling stations, is required to tally and verify the results. The appellant as opposed to its chairman. Later in the ruling, the court stated that it was further argued, that is paragraph 293, it was further urged in court by a number of counsel for the first and second resolution that disregarding from 34As and exclusively relying on Form 34B, many of whose authenticity would later be called into question in the tallying process, the said resolution was simply complying with the Court of Appeal in Maina Kiai. We have already held that we find little or nothing in this decision to suggest that by deciding the way it did, the appellate court restrained or barred first respondent from verifying the results from the before declaring them, or that was relieving the former from statutory duty of electronically transmitting the result. What the second respondent was barred from doing by the Court of Appeal and the High Court was to vary, alter, or change the results relayed to National Tallying Center from the polling stations and constituency tallying center under the guise of verifying. So here, when they say what the second respondent was barred from doing, they are referring to the chairman. And it seems to imply that the verification ought to be done by the chairman, whereas the court also quoted with approval the finding in Maina Kiai to the extent that the appellant, as opposed to his chairperson, upon the receipt of prescribed form containing tabulated results of election of president electronically transmitted, is required to tally and verify them. The Maina Kiai decision is expressly clear on the issue, and it states at page, I think it is page 104 of our list of authorities, authority number 3, in Attorney General's Case Digest and Bundle of Authorities, page 67 to 107. It says that we hold further that reference to the appellant in sub-article 3C is not to be construed to mean the chairperson, but rather the returning officers who are mandated after counting the votes in the polling station to tally and verify the count and declare the result. The appellant, as opposed to its chairperson, upon receipt, the appellant, as opposed to its chairperson, upon receipt of prescribed form containing tabulated results of the election of president electronically transmitted to it from the near 40,000 station, is required to tally and verify the results received at the National Tallying Center without interfering with the figures and detailed process. In Article 138.10, the chairperson then declares the result of the presidential election and delivers a written notification of the result to the Chief Justice and to the incumbent president. That is now circumscribed and narrow the role of chairperson of the appellant. So it is clear from that according to Maina Kiai, the role of the chairman was to declare the results, and the role of the IEBC was to tally and verify. And that is indeed consistent with the expectation of Article 10, our national principles and national values. So we humbly request this court to take this opportunity to clarify the position without, I think we need to emphasize, and based on what Justice Lena Ola was raising yesterday, the issue of prospectivity and retrospectivity. We're not going to that as the Office of the Attorney General. The Office of the Attorney General wants a clarification of this provision for future election and on how it impacts on other commissions. Is executive role conferred on the chairman, or the chairman is part of the commission and can only act in community with the commission? And that is consistent also with the provisions of the amendments which were done, some of the amendments which were done in 2017. You will notice that the commission has clearly delegated functions to the returning officers. Section 39(1)A, that deals with National Assembly and County Assembly for them to tally and verify and declare. And 39(1)B deals with the right of the returning officers to tally, verify and declare the governor, senator, and county women assemblies. But the provision purported to confer the right on the chairman to deal with presidential elections, and that Maina Kiai was very categorical that it was contrary to the provision of the Constitution, and this is what they said. They said that the controversial regulations 83.2 and 87.2 were not affected by amendments, and the object is not difficult to see. The High Court, having found those regulations, that's at page 105, to be inconsistent with the Constitution, it was in bad faith for the appellant to reenact them while pursuing this appeal. It is our firm position that the purpose for which Section 39(2) and 3 of the Act and Regulations 83.2 and 87.2c were promulgated or made have the effect of infringing constitutional principles of transparency, impartiality, neutrality, efficiency, accuracy, and accountability. So that was the position of Maina Kiai. Maina Kiai came to this court. The appeal didn't succeed, and therefore it has impliedly been confirmed by this court. So we humbly request your lordships to take this opportunity, and my ladies, to take this opportunity to clarify that position. To go back, in conclusion, to the members of the NSAC, Lord, I would like to humbly submit that these are Kenyans of integrity, highly professional, who have pulled themselves with their bootstraps and reached the echelon of our system, and it would be very unfortunate when it is left for their name to be sullied in the midst of a political context in which they have no interest. In fact, they were merely asked by the NSAC to send a message. A spokesman was appointed who went and sent the message, but they are now being tarred with the brush of having been trying to unconstitutionally alter a process which is sacrosanct and which they have sworn by their oath to protect in assuming their position. That's my humble submission, and I will donate the 3 minutes to the court. Thank you.
Thank you very much. The 3 minutes and 16 seconds are welcome.
Thank you.
Yes. Mr. Ngatia?
Thank you, Madam President. Please first allow me to introduce the lawyers who have burned midnight hours to present so many affidavits before you. My name is Ngatia Frederick. I'm assisted by the following lawyers: Mr. Kirago Kimani, Senior Counsel; Mr. Kioko Kilukumi, Senior Counsel; Professor Kithuri Kindiki; Mr. Katwa Kigen; Dr. Muthomi Thionkulu; Dr. Linda Musumba; Professor Kivuva Kibwana; Mr. Elias Mutuma; Melissa Ngania, who I had the opportunity to present a matter in 2017 with her; Mr. Mwanza Ombati; Mr. Kipchumba Mokomen; Mr. Benson Milimo; Mr. Wilfred Nyamo Mati; Mr. Edward Mureu; Mr. Hilary Sigei; Madam Monica Nyogutu; Mr. Collins Kiprono; Wanjiko Nyaga; Emmanuel Kibet; Ian Shelela; Caroline Cherono; and Chris Ayeko. Most of them are in court number 1, following the proceedings very intently. Madam Chief Justice, I rise before you. I know it's been 2 long days. Please bear with us to oppose the petition filed by several petitioners. It is the first time in the history of this country that we now have 8 petitions. It must be a new strategy to disable the president-elect to mount a defense against 8 petitions within 4 days. But we didn't manage the impossible, and we now present our defense as follows. First and foremost, my lords, let us appreciate that these consolidated petitions arise from a presidential electoral contest. It is an electoral contest. Ideally situated, or it should ideally be resolved by electorate, the Kenyan voters, not by a court of law. But because it is also part of the constitutional structure of this country, this honorable court is granted original jurisdiction by the Constitution to resolve this contest. But in resolving this contest, it is necessary to bear in mind that all you have are affidavits filed by the contestants. The difficulty with affidavits is that one can structure fiction and peddle it as a pleading, as I'll be demonstrating. I will start with Article 38 of the Constitution, because to me that is the beginning of an understanding of this contest. Article 38 is the one that empowers a Kenyan to vote by secret ballot. And that simple sentence can be broken into 3 or into 2 parts. Voting by secret ballot, meaning it confers on the individual power to exercise a freedom of choice unhindered by anything. Number two, or the second part of it, the vote gives the citizen a power or a badge of dignity